Good afternoon, Your Honors. The matter before the court this afternoon is the case entitled State of Vermont versus Jacob M. Rillo, docket number 2019-047. Representing the appellant, Jacob Rillo, is Joshua O'Hara. Seated at counsel table with Attorney O'Hara is Rebecca Turner. Representing the appellee, State of Vermont, is Paul Barkas.
Okay, thank you. Counsel?
Thank you, Mr. Chief Justice. Good afternoon. When a person tells a court that they want to plead guilty, that person must have a conversation with a judge to make sure that the plea is voluntary. Making sure that the person admits to sufficient facts to justify the conviction is an inextricable part of the court's duty to make sure that a plea is voluntary. In this case, Mr. Rillo's conviction must be reversed because although the prosecution charged him with dispensing fentanyl and heroin, causing the death of Jesse Boardman, during Mr. Rillo's conversation with Judge Van Benthuizen, Mr. Rillo said that he absolutely did not know that the heroin that he gave to Brooke Barnaby contained fentanyl. Despite noting this problem—
Why isn't the distribution of heroin alone enough? Is it because of how it was charged? Is that what you're saying?
That is on its own sufficient basis for the court to reverse his conviction. The prosecution chose to charge this as the distribution or the dispensing of fentanyl and heroin.
But the charge itself is dispensing of a regulated drug. That's the way it's captioned in the statute.
Well, yes, that's true. I believe it's under 4250, which talks about then a violation of that chapter. And when we get back through to each one of the different ways that the prosecution can charge this, each one of those requires that the person knowingly dispense whatever drug that the prosecution chooses to charge with. So as a matter of statutory construction, and this court's usual rule that where the legislature includes a scienter element, a mens rea, that distributes to each material part of the criminal statute. That would require the prosecution to show that Mr. Rillo knew what was in the drugs that he gave to Ms. Barnaby.
So during the change of plea then, if the prosecutor had heard the exchange and said, we want to strike fentanyl from the information, then that's the end of your argument?
If that had happened in this case, Mr. Rillo's admission was that he knew that he was dispensing heroin to Ms. Barnaby. That part of our argument would then be, we would not have a leg to stand on. But the prosecution specifically chose to charge this as fentanyl and heroin.
But count 2 and 3, which is the sale of fentanyl, were both dismissed by the state.
Right, and we haven't challenged those other convictions. It's just the death resulting conviction that we've challenged the factual basis on in this appeal. And I believe those, we've just challenged the dispensing with death resulting. The cause of death in this case, unfortunately, was the mix of the two. So in order to convict Mr. Rillo under this statute, they would have to have proved the mix, unfortunately.
If the charge was, I understand here it articulated heroin and fentanyl. If the charge was one of those more generic charges that said he dispensed a regulated drug, would the attorney at the change of plea, the defense attorney, have been obligated to ask the state and ask the court to require the state to make an allegation of what type of regulated drug it was?
I think defense counsel, if it had been charged just as a violation of 4234, dispensing a stimulant, depressant, or the rest, would have been able to make a Rule 7 motion to specify what it is.
Was he under the obligation to?
I think that he would have been probably ineffective if he hadn't been able to explain to his client, this is what the prosecution is charging you with. Because here, the purpose of Rule 11F is to make sure that the person understands the facts as they relate to the law. And then the court said in Bridger, the point is to make sure that this person understands how he might have violated and whether there are any defenses here.
Well, Bridger is about the elements of the crime charged, right?
Yes.
And are you
and
saying,
and the factual basis for the plea.
okay, so what are the elements of this specific crime that he was charged with?
As with any other violation of this, this part of Title 18, he would have had to knowingly dispense, and in this case, because it's a death resulting, to the person who eventually passed away, and that would have had to been the proximate cause of that person's death. Whether, in each one of those violations of Title 18, this chapter, the legislature has specifically chosen to make it knowingly dispense the particular drug. And so even if we get to a violation of 4234, where there's more generic language, the structure of how the legislature has created this violation would still require the defendant, if they're going to have violated the statute, to have known what it is they were dispensing or trafficking or the rest, even though the legislature has chosen to use that more generic language.
So wait a minute, are you saying even if it had just been charged as dispensing heroin death resulting, you'd have to, that would be a problem that if we didn't know that there was fentanyl mixed in it?
Correct. If that was, if the reason for the death resulting charge is the mix, we have a factual basis problem if he didn't know that there was fentanyl, as happened here, because that's the eventual cause of, that's the violation of Title 18, Chapter 84, that resulted in the violation of 4250. So if there isn't knowledge about what the person dispensed, as happened here, there isn't a factual.
I'm sorry, I can see a big difference if an autopsy result said this death was caused by fentanyl as opposed to heroin. What did the autopsy report say?
The autopsy report that the prosecution admitted, and it's referred to in page 15 of the printed case in the affidavit, is the mix of heroin and fentanyl. So to have violated 4250 and have that sentencing enhancement, he would have had to have known that what he dispensed included fentanyl. And that would have been a violation of chapter, I think it's 84. Even if that wasn't specifically included, this knowledge requirement, this court's usual rules of statutory construction, considering the penalty here, which is 20 years, the court would have had to read into this a knowing requirement, even if the legislature had omitted it.
This was part of a plea agreement, which involved the dismissal of certain charges and involved multiple dockets. Mm-hmm. If you're correct that that there's no factual basis on count one here, why isn't everything reinstated? And state, and you can talk about a plea agreement anew if you choose to.
Well, I think if that is possible, that is one outcome here. If the state chooses to go back and request that. The court can also approach Mr. Rillo. They can try to do the change of plea again. I don't think it necessarily invalidates the entire plea agreement or makes it so that he couldn't perform it. But the state hasn't asked to, at this stage, undo the entire plea agreement. So it's unfortunately, well, it's not before the court.
Right, but we do know that unless the defendant changes his testimony in terms of what he's prepared to admit, that there's not a factual basis, according to you, on count one.
Correct.
So whatever happens, if the state doesn't unwind the whole deal, count one's not going to have a factual basis unless the circumstances of what he's prepared to admit change.
That's correct. This returns back to pretrial status.
But you're still making the argument, aren't you, that the other sentences need to be reexamined because the death resulting case kind of bled over into what the potential sentences were on the other cases?
The very last thing that Judge Van Benthuizen said in this case is, I'm giving you this sentence to essentially send a message. So if the court unwinds count one and the prosecution wants to stay with the remaining charges to keep the convictions, there needs to be a resentencing on the rest because Judge Van Benthuizen, I think it's page 106, very clearly says, I'm giving you this sentence so that other people pause when they set out on a career of doing what Mr. Rillo had done. So the law is that when a court announces a package sentencing such as this and says this is the purpose for the overall sentence that I'm giving you, reversal of one of the convictions results in unwinding of the rest of the sentences.
But
Or the
sentences
plea
are
agreement,
Go ahead.
or unwinding of the entire plea agreement.
We're not at that stage, but it's potentially possible. That's an entirely different body of law where we talk about material elements of the plea agreement. Justice Cohen.
No, I just say that count one was sentences 5 to 10 years, and the other counts were all 4 to 8.
48, and I think
Correct.
it's page 22, I believe it is, of the plea agreement, or the printed case. They all have the ability for the defendant to ask for less at a contested sentencing hearing. There are no further questions?
Yeah, okay, thanks very much. Counsel?
Good afternoon, Your Honors. May it please the court, Paul Barkis on behalf of the state.
Afternoon.
I think the core issue in this case is not whether the facts at trial supported the verdict, but whether the facts that were elicited during the plea colloquy satisfied Rule 11. The court has made it clear at Bridger that a guilty plea colloquy has to specifically touch on all of the factual elements to satisfy the charge that has been alleged, to avoid false guilty pleas. I don't see this as a case involving a false guilty plea. The elements in this case, I think, that were identified by counsel are quite simple. That there was a knowing involuntary act of selling a regulated drug with death approximately resulting.
But that's how you define the regulated drug. I mean, the regulated drug that he was agreeable to was heroin, not fentanyl. I made that very clear in the colloquy, that he was not, did not have knowledge of the fact that the drug that was provided or dispensed contained fentanyl.
He did say that, but he qualified that, or it was qualified in the way he said it. I said, I didn't know it at the time. I do know it now, which sort of begs the question.
What difference does that make?
I'm sorry?
Don't you have to know it at the time? If he finds out later, how does that happen?
I do not. I do not. I do not. If somebody, just for example, is accused of burglarizing a house that's occupied, and doesn't know it's occupied at the time, but finds out later that it's occupied, he doesn't need to know it at the time that he's committing the burglary that it's occupied. I don't know that it's much different in this particular case. And I would say that he did admit it when he said that, I didn't know then, but I know now, which perhaps begs the question, is I know now an admission? And I would say it is. It's the equivalent of saying, I know I sold the fentanyl that resulted in Mr. Boardman's death. I think that is an admission. I think the mistake is not that the selling and dispensing. The mistake he's claiming is that I didn't know what I sold contained both heroin and fentanyl. It was not an accident or a mistake. It was a voluntary act. That's what's required.
Does he, go ahead. Does he face any more collateral consequences by having now an information with the notation he pled guilty to it that said heroin and fentanyl? If it only said heroin, that's one thing. But with the fentanyl, if he got charged federally for a drug crime in the future, would that fact that the information said fentanyl that he was found guilty of have any collateral consequences?
I don't know, and I would say that if this case were pled differently, it may. If this case were pled as a violation of Section 4234 with Section 4250 as an enhancement, perhaps it would, because then there would be a specific conviction for selling fentanyl and then the enhancement of 4250. I don't look at 4250 as an enhancement. I look at 4250 as a singular offense on its own accord. And I think that's part of the problem that factors into this scienter argument, that somehow a knowing element has to be incorporated into each and every element of the offense. I think if it were charged differently, that would be the case. But there is no knowingly language in 4250.
Would you give me an example of the different charge that you just referenced? What would be the case if there was a different charge? Explain that to me, would you?
I'm not sure.
Well, you said if there was a different charge, the knowing element here would be a different case. What, spell out the charge that you think would apply?
If it were charged as an offense of 4234 and then somehow 4250 treated as an enhancement, there would be a knowing element. We would have, because the knowing element is specifically contained.
Are you talking about because of the language in the statute itself?
Yes, sir. Yes, sir.
All right.
But
That
you've
language-
charged, the charge for the death resulting is was a person who knowingly and unlawfully sold or dispensed heroin, a regulated drug, and fentanyl, a regulated drug, which then proximately resulted in the death of a person. Take it out of the plea context. If there was a trial,
Yes.
say he presented all this evidence.
Yes.
He says, I knew it was heroin, but I didn't know it was fentanyl. Would the jury instruction reflecting this charge instruct the jury that they had to find that he knowingly and unlawfully sold or dispensed heroin and fentanyl?
If it went to trial, I think that the language would be that would follow the statute that the defendant knowingly sold a regulated drug that proximately resulted in someone's death.
So the instruction wouldn't track the actual language of the charge, it would track the elements of the statute
Yes,
without?
I believe so, and I don't necessarily know that a defendant would be entitled to a jury instruction that it is an affirmative defense that the defendant didn't know the formulation of all the narcotics in the regulated drugs.
No, I'm
that he
talking
sold.
about an instruction as to the affirmative elements of the state's case. Wouldn't it be the case that the state would have to prove that he was a person who knowingly and unlawfully sold or dispensed heroin and fentanyl? If that was what the charge was that you were presenting to the jury?
Yes, yes. Those would be the regulated drugs.
Well, wouldn't the instruction read something like this? You would have to find that he dispensed a regulated drug. In this case, the state alleges that is heroin and fentanyl. Wouldn't that be the instruction?
It could be. It could be, or it could just be as a regulated drug.
As
If
defined
it were a
as.
trial, but,
Yeah,
I
you have
mean-
to have a definition of a regulated drug. You can't just say a regulated drug. You need to put some sort of perspective to the jury so they can make a decision on what a regulated drug is, which is easily defined.
Well, what would happen between the time during trial and at the jury charge, what happens at the jury charge, a lot happens in between, and I don't know exactly whether it would be sufficient to say regulated drugs, or if my feet would be held to the fire and I would be required to show both of them simply because it was pled this way.
Assuming we don't agree with you on the count one issue,
Yes.
as I read your papers, you're asking us not to come to the conclusion that the entire plea agreement gets tossed out and everything's back on the table?
Yes, the counts 4, 5, and 6 are completely independent and separate and apart from count one. They don't relate whatsoever. They were controlled buys that happened after the overdose death.
Didn't the state make a decision on what they were willing to accept for convictions? You have counts 2 and 3 in there that are dismissed.
Counts 2 and 3 were dismissed. We had an agreement as to the structure, the overall structure of a plea agreement, and what the state would be limited to, what would not result in the plea agreement being violated and it being sent back to be renegotiated, and that was 5 to 10 years. And the court at counts 4, 5, and 6 was at less than that. It was at 4 to 10 on 4, 5, and 6, and the 5 to 10 happened only on count 1.
But that isn't exactly what the plea agreement said. There was a cap on what you could argue for, but the
Yes,
defense was free to argue for anything under that.
correct, yes.
So it's not an agreed 4 to 8. It's an agreed.
It wasn't
cap.
agreed 4 and 8, but we agreed to that structure, that it could be up to 5 to 10, because that's what the state would be asking for, and they could ask for the minimum that was required in this case, which was 2 years. But the language that that the court used in sending a message wasn't in the context of, we want to send a message. This is a 5 to 10 year sentence, and this is how I'm going to break it down. The court specifically went through each and every offense and gave a sentence based on the individuality of each sentence, and then finally resulted in the 5 to 10. And for those reasons, I don't believe that it needs to go back to negotiate. All of the sentences need to be negotiated.
What about the dismissed counts?
You see the time.
Yes, thank you, sir.
What about the dismissed counts?
I think if we're back to just arguing, having to deal with count 1, I think the dismissed counts are gone. I see that they were dismissed without prejudice, but I'm satisfied to go back and just deal with count 1.
I asked the question about collateral consequences because in reading all this, I was wondering why at the change of plea, you didn't just say, okay, I'm going to strike the language, the fentanyl, in the information, and then we wouldn't be here today. And I'm wondering if you didn't do that because there is some reason, I know you do a lot of drug cases, if there is some reason why you wanted fentanyl to be in that information.
Well, I wanted it in the information initially because it was contained in the autopsy report. Now, the autopsy report didn't use the word mix. The exact words that were used were death from acute intoxication due to heroin and fentanyl. Sometimes we see the combined effects of heroin and fentanyl. Sometimes we see mixed toxicity involving heroin and fentanyl. But when I saw the heroin and fentanyl, I thought it prudent to plead them both.
So then the way you just clarified that autopsy report doesn't support a finding that this death was caused only by heroin, or could have been caused only by heroin.
I think it could. I think if it would have said the combined effect, I think then that would be different. But I think when it says acute intoxication due to heroin and fentanyl, I think that the court is right that I probably could have stricken out with a blue pen, the fentanyl
So
part of it.
well, you could have asked for that too at the change of plea. You could have asked the fentanyl be stricken from the information.
But I could have, but when Judge Van Thuisen was done with the colloquy and Mr. Rillo said, "I know now," I perceived that as an admission to the fact that he knew that he sold fentanyl to Ms. Barnaby and Mr. Boardman, and with that, knowingly selling heroin and fentanyl to Mr. Boardman and it resulting in his death, I believed we had everything that we needed in that colloquy. And that was why the blue pen didn't come out.
I'm glad you're using a blue pen, not a black pen. Would know.
I have so many blue pens, I don't know
Yeah,
where
me
they all-
too, me
where they all
too.
came from.
I know what you mean.
Half of them don't work. If there are no further questions, I thank you for your time.
Thanks very much. Does the appellant have time?
Appellant has 4 minutes and 23 seconds remaining.
All right,
I'll waive my time.
okay, thanks very much.
The next hearing for the court will follow immediately.